Hi, I'm Nathalie Dibo, and I'm a pro bono volunteer with Legal Aid. You've taken a case, and you might have some questions. I'm here to reassure you that you can do it, and Legal Aid offers a lot of support. So thank you for joining Legal Aid's growing team of pro bono volunteers. Let's get started. In this video, we'll cover the basics of how to handle utility shutoff cases. Time is of the essence in utility shutoff cases, so you'll want to make sure you talk with the client within a day or two of accepting the referral. Prior to meeting with the client, you can visit the Volunteer Resources page of Legal Aid's website to review materials that can prepare you to assist the tenant. There are a few different routes that you can take when handling a utility shutoff situation, depending on the circumstances and jurisdiction. It's important to determine why the utility is shut off. It may be that the landlord has not paid the bill, or that there's a maintenance issue. Either way, the landlord is responsible to restore the utility. The only time the tenant would be responsible is if they have agreed to pay for the utility, or if the landlord can prove that the tenant caused the damage that led to the maintenance issue. Legal Aid tries to screen those cases before they reach volunteers. A lease should spell out who is responsible for the utilities. If a lease does not exist, the utilities are the responsibility of the landlord, unless there was a verbal agreement otherwise. If the rental unit's utility is not individually metered, the tenant is not responsible for payment. There are situations that will not fit squarely within these requirements. Please reach out to Legal Aid if you have questions. If the shutoff is the result of a maintenance issue or a landlord's failure to pay, you should begin by sending a demand letter to the landlord to get the utility restored. The letter should include the following: the date, details about what utility needs to be restored, how long the tenant has been without the utility, notice that the landlord has 3 days or 72 hours to restore the utility, a phone number where you or the client can be reached, and a statement that if the utility is not restored, then further legal action will be taken. Make sure you and the client keep a copy for your records. If you're just providing brief assistance, you'll want to have the letter come from the tenant. If you're taking the matter as full representation, you can have the letter come directly from you. If you need help, a sample demand letter is available on Legal Aid's Volunteer Resources page. It's best to send the letter via certified mail if possible. If the landlord's address is unknown, the notice could be sent via email or text message. It is also a good idea to call the building and housing department of the city or locality where the tenant resides to report the issue and request an inspection. Sometimes the demand letter will push the landlord to resolve the issue. But if the landlord does not restore utilities within 72 hours, you will need to file a motion. Most municipal courts have sample forms available on their websites. There are also sample motions on the Legal Aid website. Often, these motions will require an affidavit from your client. Generally, you'll have two options. You may either file a temporary restraining order or a complaint for injunctive relief, or in some jurisdictions, you can do both. Depending on the jurisdiction, a hearing will be set, or you may have to file a motion for a hearing. At the hearing, you will be given the opportunity to explain the situation. Be prepared that the landlord may attempt to argue that the utilities are not the responsibility of the landlord. Make sure to bring any proof you have in the form of pictures, messages, or testimony from your client or others. If an injunction is granted by the court and the landlord still does not comply, the tenant can file a statement of failure to obey a court order, and a show cause hearing will be set by the court. Note that a tenant does not need to be current in rent to receive all utilities. A utility being shut off does not relieve the tenant from owing rent, though. As a quick overview, the basic steps in utility shutoff cases are, number 1, check the lease to see who is responsible for the utility. 2, write a demand letter giving the landlord 3 days to restore the utility. And 3, file a motion for injunction or a temporary restraining order. We hope this video helps you feel more confident about how to handle a utility shutoff case. For more information and help, email legal aid or check out the resources on its website. And don't forget to report your volunteer hours. Thanks for joining us for this segment of Legalese, making pro bono easy.